Today, we are addressing the issue as to whether objections to a document is required to be decided forthwith or whether the same can be kept pending to be decided at a subsequent stage. In the last episode, we had explained in detail the role performed by a defense lawyer during examination in chief. An analogy was drawn that a defense lawyer has to play the role of a fielder during examination in chief. Now consider that you have taken the catch. What is it that you have to do? You have to appeal and have the batsman declared out. Similarly, while the prosecution is attempting to exhibit a document without following the proper procedure of course, you have to appeal. You have to appeal to the court that, my lords, this document is not properly exhibited. This objection may kindly be decided and the prosecution be not permitted to exhibit the document. Now, therefore, first and foremost, it is required to be understood what is exhibition of document. Exhibition of document is nothing more than identification of a document for future purposes. Identification of a document can be done by two modes, either by exhibiting a document or by marking a document. A document can be identified so that subsequently there is no confusion as to what document was seen by the witness. There may be subsequent issues which may arise if a document is not exhibited. This has been very beautifully dealt with in Sudhir Engineering versus Nitco's judgment. That is the judgment which deals in detail with aspects regarding marking of document, exhibition of document, how documents have to be exhibited. It has been clearly explained that a document once tendered, if permitted to be admitted in evidence, will be exhibited. And if a document is not permitted to be exhibited, then it will be marked. Why a document is to be marked if it is not permitted to be exhibited? So that subsequently also one may know that this is the document that was referred but was not permitted to be admitted in evidence. A document filed in court goes through three different stages. First stage is filing of a document on record. Second stage is marking of a document. And third stage is proof of a document. Proof of a document has to be seen at the final stage in terms of Section 3 of the Evidence Act. At the time of identification of a document, that is marking of a document, the court is not required to apply its mind to the entire case. That is to be done only at the final stage in terms of Section 3 by looking at all the probabilities. At the time of exhibition of document, the court is only required to apply its mind to the very document that is exhibited and the witness who is attempting to exhibit the document. Nothing more, nothing less. So therefore, in this context, you have to understand the statement of law. Mere marking of a document does not amount to proof thereof, because proof is separate from admission of document. Now, one may ask as to how is a document exhibited. In few courts, the practice is to mark a document sequentially. That is, in terms of whatever is filed, it will be sequentially numbered 1, 2, 3, 4, and so on. Whereas in certain courts, the documents are exhibited in terms of the witness who is exhibiting, and there is also a distinction between the prosecution and the defense. So take an example that a document is exhibited through PW3, but by the prosecution. So the documents the prosecution is exhibiting, the documents will be marked as exhibit PW3 by A, B, C, D, or 3 by 1, 2, 3, 4, or A1, A2, A3, whatever the course may be followed in terms of the volume of the documents. Whereas if the defense is exhibiting the document through the very same witness, then the document will be differentiated so as to identify later on that this has been exhibited by the defense by marking it as exhibit PW 3 by DA, D1, D2, D3, or 3A, B, C, D, E. That is depending upon the courts. In Mumbai courts, we have generally seen that the courts mark it sequentially, irrespective of which witness is marking and who is marking. So it will be exhibit 1, 2, 3, 4, 5. So therefore, it is practice based. There is no certain guidelines laid down with respect to the same. One has to also follow the Delhi High Court rules, as Delhi High Court original side rules clearly provides that a document has to be sequentially marked. Now, once the document is marked, is sought to be exhibited, what is it that the defense lawyer is to do? A defense lawyer is required to object. As explained earlier also, we have to object to the exhibition of document. Now, objection to exhibition of a document can be broadly divided into two categories. One is objection as to admissibility of the document, and second is objection as to mode of proof. We are in this episode not explaining in detail those objections which we have already explained. Objection as to mode of proof is in terms of section 62, 65 and 65b and all those sections of Indian Evidence Act which provide the manner in which a document is to be exhibited. So therefore, though the document may be proper, but the mode of proof of the said document is not proper. Maybe the author is not exhibiting, maybe the document is photocopy in nature, and all those objections are objections as to mode of proof. Now, once an objection as to mode of proof is taken, that you can insist the court that, my lords, this objection may kindly be decided forthwith, whereas the objection with respect to admissibility is to be kept pending to be decided at the final stage. Why is it so? As far as admissibility is concerned, there is a three-member bench judgment, Bipin Shantilal Panchal, which says that it is a very old practice that an inadmissible document is tendered, sought to be exhibited, and the defense objects, which delays the trial because the document itself is inadmissible. So even if it is not objected to, the same cannot be read. So you can raise the objection with respect to inadmissibility at that stage, at the final argument stage, even at the appellate stage. So if the objection can be raised at any point of time, there is no use in deciding that objection. Whereas objection as to mode of proof, you can insist that, my lord, this may be decided forthwith. Now, one may first ask, why should I object to the document if that can be raised at a subsequent stage also? No, objection as to mode of proof cannot be raised at a subsequent stage because mode of proof is procedural in nature. And because it is procedural in nature and you have not objected to the exhibition of document, you in terms convey to the opposite party that you are not serious about the mode of proof. Mode of proof, procedural, not objecting, not serious. Therefore, the secondary evidence changes color and is then considered as primary evidence. Why is it so? Because the objection, if raised at the proper time, would have given the advantage to the other party to cure the defect. By not objecting, you are not giving that advantage to the other party. Now, subsequently, at a say suppose final argument stage or appellate stage, you object that, my lords, this exhibition of document was not proper. My lords will ask that, where were you at the time this document was exhibited? Now you cannot turn the clock against the party which had tendered the document by saying that the mode of proof was not proper. So the document was itself proper. The mode of proof, though irregular, you did not object. So you have in terms waived acquiescence to the said document. Mode of proof. So therefore, it is essential that you should object to the exhibition of document on the ground of improper mode of proof. Now, one may ask that, why is it that the objection to the document be decided forthwith? Why is it that it cannot be kept pending like in the case of an inadmissible document? Objection to the document is required to be decided forthwith in view of the law laid down by the Honorable Supreme Court in RVE Venkatachala Gounder. RVE Venkatachala Gounder is a judgment which says that deciding the objection as to mode of proof has its own advantages and is fair to both the parties. Why both the parties? Because if you decide the objection, then the party which has tendered the document will have an opportunity to cure the defect, whereas the party which has objected to will also be clear whether its objection has been upheld or overruled. And accordingly, it can strategize the cross examination it has to do and the further course of action it has to do, including challenging the order passed by the court as far as overruling the objection so raised. Further, if the objection is not decided, what is the disadvantage to the parties? The disadvantages to the parties are extreme. more so for the accused, because the accused is not able to strategize the manner in which he has to proceed. He is not sure whether the document, which is in terms inadmissible, not view of its inherent inadmissibility, but because of the mode of proof. So because of mode of proof, the document is not proper, but you are not sure whether the document has been admitted in evidence properly or not, because there is a hanging sword of objected to there but not decided. So you are not properly clear as to what cross examination you have to do. You are not clear as to whether you have to cross examine other witnesses so as to disprove a document which itself is now tentatively marked. You are not sure as to whether you have to, in defense evidence, lead other evidence so as to disprove that. So your entire strategy depends upon what the prosecution has proved. The prosecution is required to stand on its own legs. You are not required to disprove, they are required to prove, because they are required to prove, and they have put in a document which is tentative because the objection is not decided. You are not clear whether the prosecution has discharged this burden or not, and therefore you will be making effort. A lot of times an accused will be making effort only because the document is exhibited but not decided. So therefore I do not know I have to cross examine or not. The accused does not know what is to be done. So in that case, to give clarity to the accused and to be very fair, the objection is required to be decided forthwith. Another disadvantage that the defense faces is, if a document is exhibited and the objection is kept pending, the defense will not know whether the document is properly admitted or not. In that case, during examination of accused under section 313, the accused will not be clear whether to answer that, my lord, this document is not proper, or the accused will have to give answers on the merits of the document. So accused will have been put a document which itself is tentatively marked, but the accused will be required to answer to the same in a definitive manner. That answer which the accused gives is only explanation to the evidence the prosecution has led, incriminating evidence. A document improperly admitted in evidence is not incriminating per se. It has to be brought on record in terms of Evidence Act. Not done so is a procedure followed not in terms of Evidence Act. So therefore, that is not evidence against you. So therefore, how can you answer to this? That is a very major disadvantage. So while arguing, you have to also point out to the court that, my lords, if today this objection is kept pending, subsequently at the stage of section 313, the accused will have to answer to this document. So first I have to cross-examine to the document, and I also have to answer to the document, which I am myself not sure whether the document is properly admitted or not, because the objection is not decided. The objection is kept pending to be decided at a subsequent final stage. Not deciding the objection also leads to delay. Delay in the sense that the party which had tendered the document can subsequently file an application under section 311 saying that, my lords, this document was tendered. At that time, the objection was raised by the opposite party. I have now gone through the entire evidence and I realize that these documents are not properly tendered by me. So, my lords may give me an opportunity to cure the defect. That ways, deciding the objection at that point of time when it is raised gives clarity to the parties. The basic rule is, the basic test to be applied is that the objection that you raise can, if upheld, give the opposite party an opportunity to cure the defect. If the defect can be cured, the objection is liable to be decided forthwith. If it cannot be cured, if the document is inherently inadmissible, then the objection can be kept pending to be decided at a subsequent stage. Now, one may ask, a question may arise, that if the objection is to be raised at the very inception, what is to be done in cases such as Section 138 Negotiable Instruments Act? In cases in which evidence is given by way of affidavit in civil cases, what is to be done? How can I raise the objection at the time? Because the document is filed, not oral evidence as given in criminal cases. In that case, you will file an application seeking decision on the objections, pointing out the objections, and requesting de-exhibition of documents. De-exhibition of documents, though not mentioned in Evidence Act, but the courts as practice de-exhibit a document which has been tendered in evidence by way of affidavit but not properly marked. There are judgments on the civil side and criminal side. On the civil side, there is judgment by our Delhi High Court, Dr. Morpen, and Hindustan Photo Films. Whereas, as far as 138 is there, there is a judgment by the Bombay High Court, Peacock. In these judgments, the court has considered that because the document has been tendered not in front of you but behind your back by way of evidence, by way of affidavit, you can object to subsequently before proceeding with the matter. But if you proceed with the matter and subsequently say that because it was not tendered in front of you, you cannot object, that is something you cannot do. It is well advised to every defense lawyer that he should file an application and insist the court to decide the objection as far as mode of proof is concerned. That if a document is objected to, then the court should endeavor to have the said objection decided forthwith. Even the latest video conferencing rules which have come provide that if a document is objected to, then the court must rule upon the same. So, therefore, the latest trend since RV Venkatachala Gounder is that you have to decide the objection forthwith. Another reason for objection to the same, and another reason you should insist the court that the same be decided, is the settled principle of law that if a thing is required to be done in a particular manner, then the same is to be done in that manner or not at all. So, therefore, if Section 65 secondary evidence provides that you can tender secondary evidence only after fulfilling the conditions mentioned in Section 65, the party cannot tender the document and have the document admitted in evidence without first satisfying the court as to the primary document. Rather, recently the Supreme Court in Shalimar Chemicals, H. Siddiqui, Sonu, and other judgments have held that if the objection is objected to, the court cannot even endorse upon the said document without first deciding the said objection. So, therefore, if you cannot mark endorsement, you cannot exhibit the document before deciding, it is very clear that today the law as it stands is objection as to mode of proof is to be decided forthwith, whereas objection as to exhibition of document can be decided at a subsequent stage. Thank you.